Welcome back to Sunrise. It's time for another Law and Order JA. And the question sent in today reads as follows. Hey, CVM, my doctor performed a procedure on me that has left me seriously injured. I have been doing some research and I realized that it was a high-risk procedure and that there were other less risky options he could have tried. I do not think that I was properly advised. Can I get compensation? All right, well, here to help us ventilate these issues and to speak on the matter is partner at Nunes Cofield Dillon & Co., Mark Paul Cowan. Welcome, counsel. Good morning, sir. How are you?
Good morning. Thanks for having me.
Very well. So, lots of things to unpack here. It seems to be in the civil litigation realm. So talk to us about what our viewer has sent in this morning.
Yes, quite a lot to unpack. So I think firstly we need to start with a key feature of medical law and ethics, yes, which is patient autonomy. Mm-hmm. Every patient has the right to determine whether he or she will submit to any recommended course of treatment. And incidental to that right is the medical practitioner's obligation to obtain informed consent. Yes. And what do I mean by informed consent? This is not just, yes, I agree. This is consent after full disclosure of all relevant details have been made. So it is important that the doctor ensures that he gets informed consent. It is required. And there are certain exceptions, like a medical emergency, urgent situation where the doctor has to step into the shoes of the decision maker. But outside of that, informed consent is required. So when one goes to the doctor and a procedure is being put on the table or put to them, then everything, the risks, the advantages, disadvantages, and the options must be put. So in this instant, the viewer is saying that those were not put to them, yes, and they are now injured, yes, as a result. And subsequent to the injury, they have done their own research and found out that, hello, there were less riskier things that you could have done. So talk to me about then what is his or her standing. Yes. Do they have a case? Do they have a matter? And how should they proceed? Right. So do they have a
cause
case?
Of action, yes.
Right. Do they have a case? It's not quite clear whether she's saying the procedure itself was also faulty or substandard, or if the procedure was performed correctly and she just wasn't properly advised. But whatever the case is, to determine if she has a case, this is different from an ordinary negligence case. This is a medical negligence case, which means that she's going to have to get medical expert opinion. So one of the things she can do to determine if she has a case is to retrieve her medical records, which should include the notes, the doctor's notes or the nurse's notes, and to write down her own experience as well and share this with an independent medical practitioner, a relevant practitioner in the field, who can verify and determine whether or not her thoughts and conclusions are in fact correct from the expert's standpoint. So it's important that you can't just go on Google, yes, and chat GPT and say, well, yes, the doctor wrong, yes, right? You can't carry that to court, right? You need expert evidence, opinion evidence on the matter.
All right, let me ask this now, Mark Paul, because some people might be saying, but well, counsel, it's going to be very hard to find a doctor in Jamaica who will contradict or go contrary to what his probably colleague or somebody already said or did. Is it possible for persons to get, say, for example, an expert from overseas,
absolutely,
and admit them to our courts in Jamaica?
Absolutely. It has been done in many cases. It's best to have local expert evidence, because sometimes you don't want to run into a situation where the other side is saying, well, this doctor is giving his opinion based on foreign standards, yes, and the foreign experience. But courts have accepted evidence from overseas experts. And if you can ground that expert evidence in local expert evidence, all the better. But you can obtain evidence from overseas.
So how do you determine if the doctor was wrong?
Well, separate and apart from getting your medical expert opinion, independent medical expert opinion, you would want to consult, obviously, with a legal advisor. And this is the type of case where you're going to need legal advice because it can get a little bit complicated, it can get a little bit technical. And so your lawyer now is going to determine what is your cause of action, whether it's a negligence claim or a breach of contract claim, because people don't realize the patient-doctor relationship is like a contract, right?
Well, that's why most of them are asked to sign.
Right. So you can have a breach of contract claim, or you can even have an assault claim, battery and assault, because if you don't obtain consent, the required consent in law, that means you would have been unlawfully interfering with the bodily integrity of another. So you can have a case of even battery and assault. So you need the legal advisor to determine what kind of case you have and to also put a value on your claim. So the legal advisor will go through and determine, okay, what are the expenses you have incurred as a result of the negligence or the wrongdoing of the doctor, and what is the value of your pain and suffering, which is based on awards previously made in courts. So that kind of assessment will be done. And then the next step is not just you're going to run to court, but you will see if maybe you can engage the medical facility or the doctor and come to some kind of negotiated settlement or mediation, as you suggested, where the parties will sit down and talk through the matter and determine if they can find common ground and resolution.
In this particular instance, right, if it is, say, the procedure was done at a government facility, a hospital, you know, the persons who probably would be looked to sue is, you can sue the doctor and the facility. Absolutely,
yes. And it doesn't matter if it's a private facility or a government institution.
Defendants. So both, you can go after both. So you're saying, go first of all, the individual should get their medical records, then seek an attorney, right, and go through and see whether or not there is a cause of action.
Absolutely. And don't forget, you need to have your expert opinion evidence as well. Google searches is not going to cut it.
You have to be like an actual person that graduate, that went to school, not a Google Doc or a chat GPT, like an actual person with an actual registered, recognized certificate or certificates, right? Yeah, not your friend. You're on a corner. Exactly, right. So you have to be very specific about this. Let me just ask you, Mark Paul, because in terms of litigation, in terms of the area of law, as attorneys at law, we can do all types of different matters, right? But I know, for example, this person might be wondering, or persons oftentimes wonder, should I go to a specific lawyer for a specific type of thing?
Yes, I would say
specific type of matter. Like, and in this case, who would I go to?
Right. So for medical negligence cases, it's sometimes best to actually consult with somebody who has experience in prosecuting medical negligence claims. Because it can get technical. It can get a little complex. So you want to have somebody that has that experience. You can go to the General Legal Counsel, see if they have recommendations for you. Sometimes you can check the newspaper reports to see who are the lawyers that are winning these medical negligence cases, and you can go and confer with them. Certainly, my firm, we handle medical negligence cases as well. So there are people out there, man.
So, but you might have a case, so don't just throw it away. Don't just put it aside because you think it's a doctor or it's a big hospital or whatever it is. Mark Paul just gave you some directives and you can follow same.
Yes, and I just want to say as well too, because I have a lot of friends in the medical community, this is really information for the doctors as well. Because you have to be aware that you do have certain duties and responsibilities, and you want to lessen your exposure to liability. And so it's important that you understand your duties and you communicate in a way that is comprehensible to the patient. It's not enough to just say, this is your condition, these are the risks, but you have to communicate in a way that the patient understands. So if you need to get down into the vernacular, you need to do that. If you need to use analogies and metaphors, you have to do that. And
meet your patient where they are.
Meet your patient where they are. And ask the patient questions as well. Tell me what you understand from what I just said to you, so that you can be satisfied that the patient has comprehended the information you have provided.
Very well done, sir. Thank you so much. Good information. Yes. our very own attorney at law here, Mark Paul Cowan, partner at Nunes Schofield, Dillon & Co. Thank you for those questions, and we want to encourage you to keep sending those legal questions so that we can ventilate the issues right here on Sunrise. Right after this, you're protecting the future of our nation's children. We're going to be learning more about this right after this short break. Don't move a muscle. Please do stay with us.